Good Monday night, and thank you for joining us tonight on In Focus. I am Thabo Mdluli, and we continue our conversation tonight on that landmark judgment on the Ingonyama Trust. The Pietermaritzburg High Court making that decision that some are calling a landmark ruling by declaring the actions of the Ingonyama Trust Board unlawful and in violation of the Constitution in initiating leases with people already residing on the Zulu customary land. The court also ruled that all the leases are invalid and has ordered that the trust to refund all monies received through the leases, which could run into hundreds of millions, as the trust is reported to have collected about 90 million rands in leases from the 2018-2019 financial year alone. Joining me now to unpack the significance of this is the director at the Land and Accountability Research Center, Nolundi Lwaya, and regional director at the Legal Resource Center, Sharita Samuel. To be a part of the conversation tonight, you can send us your WhatsApp comments and questions, 072-110-5584. Good evening to you all, and thank you very much for joining us tonight on In Focus.
Thanks
for having us.
Maybe, Sharita, just give us context of this. First and foremost, your involvement with this particular case. Where does it begin?
Well, the LRC is acting or acted on behalf of the KSAC and on behalf of the Rural Women's Movement and the individual applicants that formed part of the application. So the LRC was instructed through the Land and Research Accountability Center, that's LARC, that worked in partnership with the LRC and the CASAC in order to represent the LRC, in order to represent the applicant. So the LRC were the legal team assisted by 4 advocates to place this matter before the PNB High Court.
Yeah. But listening to the arguments then, Sharita, what led to the decision in 2017 by the Ingonyama Trust to then issue out those adverts to say those who hold PTOs must approach the Ingonyama Trust with a view of upgrading these PTOs into long-term leases? I mean, what was the thinking?
Goodness me. So your guess will be as good as mine, because there was no rational explanation put forward by them. Suffice to say that they informed the affected residents that it would assist them to obtain finance, and because it would be a more secure right of tenure. So that is why it is said that they misled residents by providing them with incorrect information.
It would be a more secure right of tenure as opposed to a PTO, which, of course, is a right to occupy. What is the difference between the two? I know one is a more formal form of land tenure. The other one is a more informal.
Well, the PTO gives substance to the customary right to the land that is protected by the Constitution. In other words, these are rights to land and property that the people living on the trust-held land have held and exercised and used and enjoyed for generations. What the ITB, what the Ingonyama Trust sought to do was to alter that unilaterally, without notice and with inadequate information to the residents, to a lease agreement, which we know is a weaker form of tenure. And it actually also took action against them for breaching those lease agreements when they defaulted on the rental payments. So in other words, they moved from being holders of a secured right to that land, to use it, enjoy it, to occupy it, to being tenants on land that they actually had a constitutional right to already.
Listening to the Minister of Land Affairs, Togo Didiza, earlier on, she was saying that the courts deemed that this change from the permission to occupy to actually setting up these lease agreements was almost a dispossession of a special kind.
Yes, Yes, it was, because there was no authority to actually depart from the permission to occupy into the conversion of the lease project that the ITB embarked on. And they did not have that authority in law, and neither did they receive the approval from the minister or from Parliament to do that. But the dereliction of duty in respect of the minister arose that despite knowing that the trust was engaging or proceeding with the lease conversion project, there were no steps that were taken to actively stop it.
Now, Nolundi, who are the individuals that decided to take up this fight to actually right and fight for their personal rights and right the wrong that was being done by the board?
Tabo, this is a collection of very brave individuals, many of whom signed these leases without being fully informed, as Sharita has alluded to. Some of them are quite senior citizens, many of them are of the pensioner age, and they were told that these leases, would further secure their land rights, and they signed those leases without a full understanding of the terms and conditions of those leases and the types of repercussions that they could face if they were to default on paying their rental amounts. So really, these were people who thought that they were doing something that would improve their land rights, that would put them in a better position in relation to the types of rights that they held, but who actually inadvertently, once they had these lease agreements explained to them in their own languages, were able to realize that they had put themselves into a position that they certainly wouldn't have chosen had they had a fuller understanding.
And what does this mean now, this judgment and the instructions, the order coming from the court in terms of what the minister needs to do now? How does that put them at an advantage, and how does it empower those landowners?
So it puts them at an incredible advantage, Thabo, because it's an absolute clear affirmation of the strength of their customary land rights. It makes it very clear that in the democratic dispensation, it is inconceivable, really, that people who hold PTOs, which we must remember were a limited form of right that was only given to black people under apartheid, would then have that right further degraded by having it converted into a lease. So the judgment is an absolute affirmation that the rights that people hold under customary law, the rights that they hold that might be considered to be informal land rights, are strong rights and cannot be undermined by actions such as converting them into leases. In terms of what this means in relation to the minister, I think it places the individual applicants, but also all of the communities who will be impacted by this judgment, in a very powerful position to watch the minister closely and to ensure that she does everything that she can to make sure that this judgment is given effect to. The judgment is quite clear that the rental amounts that have been paid must be paid back, and it is up to the Ingonyama Trust to effect that repayment, which the minister must monitor. She must report to court every 3 months and give an indication as to where things stand in terms of effecting the judgment. So really it gives these South African citizens who live in areas that many of us may have forgotten about quite a powerful leg to stand on to hold the minister to account and to make sure that she protects the rights that they hold.
Yeah. Now, this has been an outstanding issue for a while now, so much so that the debate has been ongoing, including a panel that was set up, a panel which also said that the actual Ingonyama Trust Act was actually unlawful and needed to be repealed. Now, recently, the leader of the IFP, President Velenkosi Nhlabisa, saying that this is the land of His Majesty's forefathers. He fought for against colonial rule and against apartheid, and saying they are expecting that the government of the ANC will do right by the king. What do you expect the response, Nolundi, will be from the regent king that's just taking over now?
Look, it's difficult to predict how exactly he would respond, but I would be very surprised if he didn't receive the judgment with a positive attitude. And the reason that I would say that is I think the judgment, but also the structure of the case was very clear, that this was never a case about or against the king himself, and it was never a case that was about undermining or further sort of relegating Zulu customary law. And so the reason why I would believe that the king or the regent king would receive this judgment with a positive attitude is that what it does is it reaffirms Zulu customary law. It reaffirms that land rights that are held under that system are rights that are akin to ownership and must be respected and treated as such. So really, I think the judgment casts Zulu customary law in a positive light. It underscores it and affirms it. And as I say, there was never any intention with this case to undermine the position of Isilo or to attack the position of Isilo.
What does this mean then as far as the processes that are underway already, particularly when you're talking about informal land rights, and the courts have been saying that in the absence of the fact that there is nothing formal currently, we know that there's a process in Parliament and a bill that has been looked at. What are the implications for that bill, this particular judgment?
Look, that bill is going to have to think very carefully about how it treats customary land rights. You're quite right. At this point, all we have is an interim act, the Interim Protection of Informal Land Rights Act, and the process that's underway in Parliament around a communal land tenure bill is really going to have to pay cognizance to this judgment. Because what's very clear is that you cannot possibly try and give people any form of right that undermines the strength of the customary land rights that they hold. And so the shape and nature of any version of a communal land tenure bill must bear that in mind, or it could potentially be challenged on similar grounds such as these. So one of the core takeaways, I think, for that process of crafting the communal land tenure bill is the acknowledgement of the strength of customary rights and the duty that is placed on the minister, but also on the state, to respect, promote and protect those rights.
Director of Land and Accountability Research Center, Nolundi Luwaya, with us, as well as the Regional Director at the Legal Resources Center, Sharita Samuels. You're a part of the conversation tonight. Tweet us at Newsroom405. WhatsApp your questions and your comments on 072-110-5584. We're discussing the judgment coming out of the Pietermaritzburg High Court. What is your response to that judgment? The judgment saying both the Ingonyama Trust and the Ingonyama Trust Board acted unlawfully and in violation of the Constitution by concluding residential lease agreements with persons living on the land held in the trust by the Ingonyama, and concluded residential leases agreements with persons who held or were entitled to hold permission to occupy. What are your thoughts? Let's get those comments in a moment when we return. In Focus continues next. Tonight, a focus on the impact that the ruling by the Pietermaritzburg High Court will have on the existence of the Ingonyama Trust, but also on the land tenure rights in the country, and that process that is currently underway as conversations are going on around that bill and what the final bill is going to look like. Let's get your responses to that judgment tonight on 072-110-5584 or on Twitter at Newsroom405. We are with the Director at the Land and Accountability Research Center, Nolundi Luwaya, and the Regional Director at the Legal Resources Center, Sharita Samuel. So, Sharita, the courts did not only just find on the Ingonyama Trust Board, but it found on the Ingonyama Trust itself, but as well as the minister. What did it say on the trust itself?
Well, the judgment was quite clear in that the trust had actually acted in an unlawful and unconstitutional manner in converting the permissions to occupy to the lease agreement. It was quite clear that this conduct was unacceptable. And as Nolundi has explained, the purpose of this legal intervention was not to challenge the trustee of the trust. It was against the conduct that impacted so negatively on the rights of the people that lived on the land. And when one thinks of a trust, one considers the purpose for which it exists, which is to protect the rights of the intended beneficiaries. And these intended beneficiaries were, in fact, the beneficial owners of this property. The trust merely holds that property in trust for them. That was the purpose for which it was set up. So the court's declaration of it being unlawful and invalid, in other words, the conduct of the trust, I think has demonstrated that that deference and respect which is accorded to the trust, to the board, and to the trustee was not reciprocated by the trust in the kind of the treatment, and in that what it meted out was actually a watering down of rights that people had enjoyed for so many years.
Now, let's look at what then essentially this means, that now this land, essentially, I mean, if my understanding is correct, that the individuals would now need to be actually given the title deeds that they actually own this land. Now, when the Ingonyama Trust Act was put in place, it was as we were coming into the 1994 dispensation, and there was fear that land that was previously belonging to self-governing territories was now set to become automatically public property and belong to the state. So this dispensation was created to ensure that the Zulu nation then keeps this piece of land that they will continue to administer for generations to generations as communal land under the, as you mentioned, the customary law. What does the fact that now the individuals will hold those title deeds actually mean? And do we still need to have an Ingonyama Trust?
So the judgment does not say that the land rights of the people would be recognized in the form of title deeds. What it does say is that the prior system of the permission to occupy, and as Nolindi has explained, that this is a right that was, or this was a form of tenure that was decided on by the apartheid government that would be granted to people who lived in the Bantustans. So it was specific to black people and who were just permitted that type of tenure. So what the judgment does is that it says that until such time as the minister or parliament implements laws to protect the rights that are held by the affected people, that permission to occupy system will it will revert to that system. That is what the judgment says.
Right. So does then the permission to occupy give them the economic security to give surety, maybe to banks with that piece of land?
Well, that I'm not sure whether it does that, but definitely watering it down further to a lease agreement and to mere tenants certainly will not grant them the security to secure finance in order to engage in any commercial or individual activities. But what we must understand is that the permission to occupy has sustained such residents for generations. Many of them have relied on it and have conducted their financial affairs as per that system in the past. And there shouldn't be any reason, given where the constitutional project of law reform is currently, and given the dereliction of duties by the various powers that be, in order to put in place land tenure systems and land recordal system and land title systems, then it must be so that people that hold such forms of tenure must be accommodated in undertaking commercial activity.
I suppose then what I am asking is who are the owners of that land? Because the residents on the Ingonyama Trust land have permission to occupy, but they don't really have the ownership rights completely, if I understand you correctly.
I would say that that land is then owned by the state and it is administered by the trust. And until such time as our land reform and our land redistribution programs and projects are set in motion efficiently and effectively, that is the system that currently operates in our country.
Yeah. Hence, then it brings me to that point. You're saying owned by the state, administered by the trust. What is the trust's role then in that equation of administering the piece of land?
Well, the trust is required to administer it in a manner that serves the interests of the people on whose behalf the land is held by the trust. That means, for example, assisting with the provision of services, employment opportunities, certainly not doing anything to take away the rights that they may have held already.
Now,
the trust did not have the authority to do that, as the judgment succinctly explains.
right. Not only what then does this mean for example, women-headed households who now hold the PTO, should one of them pass away, what happens? Is the PTO transferable?
So, Tabo, this is a critical question. The PTO is certainly a better position than the lease. As you point out, some of these households are single woman-headed. Some of them, of course, are also dependent on the social grant, right? So imagine having to be paying rent from a social grant amount. But your question about what happens in the event of someone's passing and the transferability of PTOs, under the old apartheid system, there were quite strict regulations around the ability to transfer these PTOs. But in practice and with the transition to democracy, people do transfer them. We must also remember that with the PTO, you do have the option of upgrading it. We have a law in our country that was passed in 1991, the Upgrading of Land Tenure Rights Act, ULTRA, which provides exactly for a process through which people who hold these limited rights that were granted under apartheid could go through a process to have those rights upgraded, and in that case, the PTO would be upgraded to a title deed. So that also is an option for people who hold PTOs who would wish to do so. But even in the event where they haven't upgraded and they haven't gone through that process, there is still a measure of transferability, and people do in practice bequeath the rights under PTOs. And certainly a woman, single-headed home with only a mother who holds a PTO right is in a much better position than she would have been if she held a lease, because of course, as Sharita points out, a lease is a much less secure form of tenure, and one for which one is also having to endure immense financial consequences. Those lease agreements had a year-on-year accrual, an increase in the rental amount. So it really not only was about the security of tenure, but there were also significant cost implications.
Now, with this process in place, or at least the one court challenge, that hurdle being overcome now, but of course we still have the minister to implement the alternative system of recording customary law. And when that bill is in place, does this then open up the conversation of whether or not we still have a role for the Ingonyama Trust, considering that the panel that was set up by the president actually recommended that the Ingonyama Trust be repealed?
Look, I think that this judgment is a moment for pause for the Ingonyama Trust. I certainly can't say that, if we were to have a land tenure system that provides space for customary law land rights, that there would not be a need for the Ingonyama Trust. Remember that, in addition to kind of administering the land, obviously the trust plays a role in the sense that, a percentage of its income is actually supposed to go to the communities who live on the land that it administers. And so one, would beg the question, aside from the kind of land administration role, what other benefits, what other provisions does the Ingonyama Trust give to the people who live on the land underneath its administrative authority? So certainly I think this is a moment of pause for the trust, for it to think about, how it is seeking to give effect to people's rights, and the ways in which it is going about doing its administrative duties and playing that administrative role.
Now, of course, Sharita, many, particularly the chiefs, will view this as an intensifying effort to disband the trust and take away the land it administers. The king successfully, in the past, opposed this. Do you think you're going to get similar kind of opposition, and are you ready for it?
Well, as Lelundi has expressed the view, and I must say that I am hopeful as well, that actually all the traditional institutional structures, including the king, are going to be receptive to the judgment and what it offers as a new era of actually compliance with the intention of the trust and the constitutional land reform project. So it may well be that there will be pockets of perhaps resistance, as there are and as is the right for it to surface. But I think we remain hopeful that there will actually be acceptance of Judge Madondo's judgment and what it actually envisages for all people of South Africa, that they be accorded the respect and that the hardships that have been experienced and the deprivation associated with arbitrary land dispossession is actually redressed. And that was the kind of intention behind this court intervention, was to assist and to give effect to the substantive right of equitable access to property for all, notwithstanding that you may be living on trust-held land. As South Africans, they shouldn't be treated in a way that is different from any other person that may be seeking security of tenure and more secure systems of land ownership or occupation in our country. Because even though we have had legislation that would have enabled many of the residents to upgrade their PTOs to a more formal recordal system, this hasn't been happening too much in practice because of the institutional, traditional, and the governance systems under which the people live. So it is really sincerely our hope that this judgment will actually augur a period of actually recognizing that and giving substance to what is intended by Section 25.
Sharita, I appreciate your time. Nalundi, thank you very much for joining us as well. That was the director at the Land and Accountability Research Center, Nalundi Luwaya, and the regional director at the Legal Resources Center, Sharita Samuel. And thanks for your engagement as well tonight. When we continue in a moment, the PSC, the Public Service Commission report for the period from January to March, coming up with some scathing findings for provincial as well as national government. We'll get you the details as we're in conversation with Dr. Bruno Luthuli, the commissioner at the PSC. Stay with us here on In Focus.